We're going to open up the meeting of the State Board of Elections today. I'm Peter Krasinski. With me is Commissioner Kellner, Commissioner Casale, and Commissioner Spano. First item of business today are the minutes of July 12th and July 26th. Is there a motion, any discussion or a motion on those two sets of minutes?
I move adoption of the minutes.
Second. Moved and seconded. All in favor?
Aye.
Aye. So it's closed. And we'll move on now to unit updates. And our first one is executive, Kristen Dabrowski-Stavisky and Todd Valentine.
Well, we just finished the filing period with regard to the Supreme Court. Well, things could still come in the mail today. So that got us there. Early voting obviously began on Saturday for the August primary. Turnout slightly below the numbers were for the first 2 days of the June primary, but as of this morning, we didn't have the New York City numbers yet. So
I think we do. I think
they
it's
might be
about
there
33,000 statewide.
So you know, we're running about on par. And we have numbers available also if you're interested for the two special elections, congressional special elections that are running. Hard to tell whether they're above or below, but it's low at this point. And that'll continue obviously through Saturday, or Sunday rather, through the next Sunday, through this weekend, and then the primary will be on Tuesday. And the staff has put together our standard procedure for, you know, securing the election itself, both on a physical side and a cyber side. So those, we do a check-in with our partnership team, which would include the Department of Public Service, the Division of Homeland Security, you know, just keeping apprised of any situations that occur. So it was a quiet weekend, so we didn't need to have calls. Otherwise, we have a call scheduled every morning at 10 o'clock and only cancel it if there's nothing going on. Yeah, I think that's a lot. And we did mention it during the Public Campaign Finance Board, because it does affect the State Board, obviously, is just the space planning. We have a series of meetings with the Office of General Services, with our space planner. We're still on target to construction. It's supposed to be beginning at the end of February, beginning of March of next year. We're still looking to finalize the furniture order itself that would replace these tables, chairs, you know, getting all the carpeting. So that will be finalized in short order. We're just waiting for the final tally on that. So we'll have all of that ordered in place. What we don't have is space for the entire staff to vacate the floor at this point in time. So right now we only have about enough for half of the staff to leave the floor. So construction may have to adjust depending upon how much space we can clear out. They are still trying to find space, but so far they haven't. And we have finished, just on that very quickly, we did finish the renovations on we have a chunk of the first half, the front half of the first floor. They're scheduled to move back in on Wednesday, so that was one project that we got done, which did add additional seating in downstairs. So that was a good project to have done. They're doing the cleaning today or tomorrow, and then they'll move back in on Wednesday. So that's our facilities for now. Kristen?
No, I think you covered it.
Any questions?
How difficult is it going to be for you to operate while that's all going on?
Well, they'll set up temporary spaces, and what we've put to them is depending upon which section you do when, we have to have operations. So right now, if that occurs in March, you know, we would have petition filing the first week in April. So we would have a spot. We need to create a spot for people to come and file petitions. Now, granted, it's not a big year for us, it's primarily JD delegates and state committee, but we would still need a front counter. So, and they said they would work as to which, they're not even sure which part they want to do first. So we should be able to figure out some type of an organization. Now, the problem is going to occur when we get to board meetings, because if this room is not available, we'll have to move down to the third floor. They have a meeting space that we can use so we have plans in place, but right now, they'd like us to vacate the entire floor, in which case then we'd have to have, well, where is that other floor? And then find out where people would come to drop off stuff. And it's not just petitions. We get a lot of in-person people who drop off registration documents for campaign finance committees, mail, lawsuits. We get a lot of stuff in the mail. A lot of voter registration forms come in the mail. Next year should be relatively quiet. It's not a presidential or big year that drums up support. So that's the biggest worry we have is, being operational during the construction period, because it is expected to last through most of 23.
How are they bidding this out if you have so many variables coming close to when you're supposed to do all this?
Well, the bidding is, the furniture, there's no bid on that. It goes to Courtcraft. So that's the way it is. That's just the state. The bidding itself was already done because there's a vendor that OGS had already provided for a contractor, so
But
they give you the price
usually
on
the
that.
bidding has a time framework
Yep,
and a work framework.
yep, it'll have that in there.
And when you vary it, you get change orders, and now you're into
Yep.
more money.
Yeah,
So why isn't it better just to get a bigger space for more money right away and avoid all that?
that's an excellent idea.
Mhm.
It just hasn't happened because, as they explained to us, they've renovated the rest of this building over time. We're like the last floor and parts of the first floor that have never been renovated. So, and it's more cost effective long-term because they don't pay rent here. The state owns the building. So they'd rather spend the renovation and keep us here rather than leasing space. And even for a short term, they don't really want to lease space either. They want to find underutilized or non-utilized state space they can temporarily move us into, as they did in the other floors in this building. Now, they had different operational needs than we do. We need a presence where people can actually physically find us. If the IT unit moves somewhere else, they can operate more remotely. They don't have the public coming in to see them. They don't have that same needs we do. And the same thing with the other programs. They don't get the public coming in, and once in a while somebody wanders in. So yeah, no, we have suggested that, but that's the rationale they've given us. This is more cost effective to stay here, do the renovation, and long term they'd have a more usable space.
We were also told that it would take, 18 to 24 months to do a lease agreement?
It takes a
You
little
mean
longer.
with another facility?
Yeah, for outside.
But every other floor did completely move out. They were given
That's true.
additional space. So we're hopeful that
We're hopeful.
they will do the same for us.
So if they go to a smaller government, they could do this.
We still have a considerable footprint.
Yeah, I know, I've been through it, and it's not easy. It
No.
screws everything up,
No.
and the money starts going this way.
Yeah, this is. Yeah.
We're all in agreement.
Mhm.
I guess there's nothing we can do.
I try to get a space
We're
that
there,
works for us.
OGS mercy on this, I assume, as far as how this actually works.
It is, but we've been very strident about what our needs are. And, we have we need office space for enforcement attorneys, we need office space for the attorneys. We need meeting space that works and is adaptable for, both boards. Obviously, we have facilities that we need to accommodate for our IT needs. We need connectivity to those, even though it's off-site. So we've been very pushy about what it is we need and getting the size of the workstations as best we can for the workload that the different people within the different units use. So we have a variety of sizes, and then also try to accommodate the environmental factors. So one of the things that we're doing for that is to not necessarily lower the cubicle walls, but to take the top foot and make them glass, so more light can come through, and that will help. So we've been pretty pushy, actually.
Okay. How long did you say this was going to go?
The project?
Yeah.
Well, that's not really clear because they had given us, I think, 7 to 8 months when the understanding was that this entire floor would be vacated. So I would have to assume that it would add time and money to do it partially. But we have a new project manager for the 5th floor, so we sort of transitioned to meetings with him. We had our first one, it'll be 2 weeks ago. So we're gonna meet bi-weekly with him. And he seems responsive. And we every meeting, we talk about swing space, we need swing space, so we are very forceful.
And how many people on the staff can do their work from home? Efficiently.
Well, you know,
Productively.
yeah, that, you know, certainly large chunks of them, that's not really an option, because if we have to intake petitions, they're all physical items that have to be here. The voting system and all the approval in the operations unit, those are all physically here. Even the campaign finance, both on the public campaign finance side and the regular campaign finance side, the initial intake are all physical documents that have to be reviewed. So once they're in, then reviewers can do some of that work at home, but then they would be relying upon their resources to, you know, the connectivity that they have at home, you know, and that exacerbates our security needs.
I understand.
Because once we go that way, so it's doable, and to the extent feasible, we've had remote working, but it does make it much more challenging on a certain amount of connectivity level.
When this is all over, is there any thought of looking at the structure of what we have and moving into more remote work and stuff like that?
Well, we're going to build the facilities going forward that'll make it easier for that. Because right now, in order to work remotely, you have to have a workstation here, a physical presence here. And that's just by design of the network. We always did that way for security purposes, and we maintained that when we started with COVID. Going forward, what we want to do is cut that tie to the physical space here and migrate more of that computer use into the cloud so that we have that flexibility. Can't do it right now, but that is the next generation of our workstations that we're going to go to that will give us that ability to either use what are called hoteling stations, where people are here physically. You know, they don't have like a regular workstation. They'll have, you know, a hoteling station where they can come and go. And we've incorporated those into the furniture design. So we did that on the first floor because we have more of those workers that come and go with our contractors, so they don't get a full-blown cubicle. They get a workspace where they can come when they need to. And that's something that we're putting into the design looking forward. It just can't really give you numbers at this point when it's going to occur. So we're trying to plan for it, yes.
And there are several in the public campaign finance that I think they work like 2 days a week remote. So they have started to try to implement that wherever it's feasible.
Yeah, but it's just that as long as the thinking is going on, it's fine.
Mm-hmm.
There isn't one corporation, one business that I know that isn't doing something like this. But of course, they can move at different speeds.
Yeah.
And I understand that. Yeah. But I think that, you know, and you have no idea what technologies are going to be available to you 2 years from now. So as long as your head's into it, I think it's okay. We're there.
You all set, Senator?
Yeah.
Or, Commissioner? Okay, then we're done with the executive report, and we'll move on to the election operations, Tom Connolly and Brendan LaValle.
Thank you, Commissioner. As Todd mentioned, both early voting has started, and that's going so far so good. We have been providing support to the county boards both on the run-up to early voting and also throughout the process. We did receive filings for Supreme Court. We did receive 22 in total nominations. All of the districts were represented. There's no vacancies in the 6th Judicial District. All of the other districts, we received nominations from the Democratic, Republican, and Conservative parties. We received only one Working Families nomination. That was for the 8th JD. We have been collecting statements of canvass for the June primary and other election-related documentation for both the June and the August primary, as we typically do. We did hold a WebEx with 25 counties to talk to them about using the vendor solution that we first used at the June primary for aggregating results. This was a need that came out of the change in law about the canvassing of absentee ballots prior to Election Day, and the inclusion of those results in election night reporting. And so what this system does is allows counties, since they're not really allowed to work with results until at the earliest 8 p.m. on election night, it allows them to take the results from two different systems. In the case that we're dealing with at least the 25 counties, they're using the clear ballot system for central counting of absentee ballots, and they're using Dominion for their early voting election day ballots. And this allows them to kind of marry those results together very quickly so that they can provide all of that information to us on election night. The first go-round worked very well. This go-round, we added a couple of counties that did not use it in June yet, but hopefully it will also go smoothly. Coming out of some litigation that I'm sure council can address, we have also procured an accessible absentee portal. This came out of the Hernandez litigation. We've been working with the counties at both the June and the August primaries to follow the procedure that was put in place for accessible absentees, which largely consisted of the county boards getting all of their ballot PDFs made accessible. And then when a request came in for an accessible absentee from a voter, they would email the voter that accessible PDF along with some, what we usually call origami envelopes that they could print out in folds if they wanted to create an envelope set to return their ballot. The boards also have to mail out a physical packet of envelopes for the voter to use to return if they should so choose. This will be, the new absentee portal will be in place for the general election. It will be a different kind of a model where the boards will be required to upload the ballot information will be more similar to the military and overseas voting. And then any voter who has requested an accessible absentee will be able to access that portal. Will be able to go through the different contests and candidates that they have that they're eligible to vote for, so make their selections and be presented with an accessible marked PDF that they can then return by mail to the county board. So we are currently working with the vendor and getting the statewide site set up as far as customizing the user interface to make sure all the language is New York specific. We will be working with the counties in the first 2 weeks of September after the August primary has been finished to kind of get them up to speed with how to use this new portal so that when it comes time for us to certify mid-September, they will be ready to upload their information to the new system. I will also be heading out this week to visit 11 of the 22 counties that have both the special election along with the primary election. So I'll be hitting the special for the CD23 on Wednesday, with being 6 counties there, and then 5 counties in the old CD19, just to kind of see how that's being done, how it's being implemented. With regard to voting systems, again, we have 4 voting systems, or 4 vendors currently under certification testing. Dominion, we are still just finalizing the testing plan. You'll hear this a lot on some of the other systems. Basically, what we do is we have 2 testing partners. We have SLI, which is one of the 2 federally certified testing labs for voting systems. And we also use NISTech for an independent security consultant. What we do is we have SLI do the first pass as far as determining what are the different requirements under New York State election law that might apply towards the system and how they're going to go about testing it. We then make sure we pass that through NISTech to make sure they agree with that assessment and that they believe that the testing approach is correct. And then once we're all settled, we can kind of move forward with each individual system. So the Dominion, for Dominion, the system is currently, the testing plan is currently being finalized. We expect to receive hardware for all the new equipment here next month. The equipment that was submitted has already been given to the testing lab, so they already have that on hand. With regard to clear ballot, there are 2 flavors of clear ballot that are currently being looked at. One of them is 2.2, which is really just for the central count. I would expect that we would have the resolution for you to consider at the next meeting, along with all the testing documentation. That was just an update to the existing central count software, largely having to do with New York City, because there was a limitation in the old software with regard to the number of ballot styles that the software could handle. And New York City, in a general election, would typically go beyond that number. So they've been fine for the June and the August primary, but they would definitely be looking to hopefully be able to use the software for the general. The testing partners are just finalizing their reports. Once they provide them to us, we'll put them together with an executive summary and we'll provide them for you for your review. And then, like I said, we would anticipate having a resolution at the next board meeting for 2.2. 2.4 is actually Clear Ballot's full-fledged voting system. They've never had one in the state before, so this is to be used at the poll site. We've been discussing with them something, because there is some shared code between 2.2 and 2.4. We do believe that there are some changes that need to be made to 2.4 before it really can get tested. So they will be working on some of those source code changes. We may move ahead with some other testing, like environmental testing, what they usually refer to as shake and bake, because they actually will heat up the room and do some shaking of the equipment to make sure that actually can stand up to certain criteria. So that if we can do that while they were working on any kind of updates to the source code, we could try to keep our overall project timeline for that in place. HART, also a new vendor to New York. They did complete and get federal certification for the system that they're submitting to the state board. So we will be providing them what we call transfer credit for any testing that they did at the federal level that could be used for the state testing. Otherwise, we'll be working on doing the Delta, so that's being kind of finalized, what remains to be done, and any New York State specific requirements. As far as Esnf goes, they did come back at the beginning of August. They brought all their equipment in and they did a demonstration for our staff and for NISTAC. So we were able to have kind of a hands-on with the new equipment, ask a number of questions, get a demonstration of the basic overview of the system. So that's still at the very, very beginning of the process, but we will be working on figuring out what the testing approach looks like. A lot of this hardware has already been tested under the previous submission, which was 6041. This new submission is 6301. So ESNS will be putting together some documentation as to what they believe can be used from prior testing for this new system, so as to kind of, I guess, be as efficient as possible with what testing we actually do have to do. And then as far as e-poll books, we will be reviewing and testing configurations from all 3 e-poll book vendors. We did just receive 2 of the 3 last week. We're expecting the last one today. The goal would be that, again, for us to have the testing done and completed and reports and resolutions for approval before you at the next board meeting, so that county boards have enough time to update their fleet of equipment for the general election. And beyond that, I think that's all I have. Brendan, you got anything?
I'm good, thank you very much.
Any questions?
Any questions? I have something.
Sure.
One of the things you talked about earlier was you're going to go out to some of the counties that are running both primary and a special. What kind of issues are you looking at when you visit these counties?
Well, we try to provide guidance to the counties ahead of time, both with regard to the programming of their ballots, because we knew that it wasn't likely that any of these counties had enough machines to have separate sets for each election. So we provided them with guidance on how they can program their ballots so that the ballots for the special and for the primary could be read on the same machine. Then we also followed up with some guidance with regard to the electronic poll books, because it can be done in a couple of different ways. There are obviously different considerations that have to be considered because of the different cutoff date for voter registration, with the special election being 10 days before the election and the primary being 25. So each of the different systems have different ways of going about it, and all 3 e-poll book systems are involved in at least one of the counties of the 22. And some of the counties also, it's a lot easier because they were wholly contained in the all district, so every voter gets a special election ballot. There were far fewer, but still a handful of counties where only part of the county was in the old district. Some of them were actually in old election districts, which no longer exist because of redistricting this year. So it definitely is a unique situation. So I think the boards have been doing their best to try to figure out how to administer the elections. My goal to go out there is just to kind of see how it's actually being implemented on the ground, if it's being clearly communicated to voters as they come in, that there are 2 elections that they are able to do. If, you know, some boards are using ballot on demand printing, so a voter might go in, check in once, and be handed 2 ballots. So I'm just kind of curious to see the different choices that all the counties made.
Anything else? Okay, thank you.
Thank you.
The next is council, Kim Galvin and Brian Coyle.
Thank you, Commissioner. We did a little reprise of our ballot access litigation season, for lack of a better word, and we had 46 cases relating to what I would say are garden variety ballot access matters, and roughly half a dozen cases that related to circumstances that came about as a result of the Harkenrider order. I'm pleased to report that as of right now, we have no case pending with the state board as a defendant that would imperil the ballot. We still have potentially future cases to come with respect to Supreme Court, and we certainly have cases potentially related to the results of the August primary, but ballot imperiling cases have been resolved, and that is frankly a better position that we're in right now than I might have anticipated. There is one ballot access case actually that we are technically a party to in Erie County related to a nomination for a judicial position at the county level. And we are only a party to that case because the rules of the party are filed here and also with the local board of elections. But it's fully expected that that case will resolve itself and again, only involves elections in Erie County. There are, of course, a number of cases that are continuing to be pending. And actually, before we get to those, I would note that at the last board meeting, the board authorized council to make an application to ask Supreme Court to Benton County for a cutoff date for voter registration, for party enrollment changes with respect to the August primary. Within a few hours of the board meeting, we made that application, and the court the next day ordered the party enrollment change cutoff for the August primary to be August 11th. And that, I think, has alleviated a number of the concerns that the board expressed, all of the concerns the board expressed at the meeting that precipitated that application. As far as cases go, in the Libertarian Green Party case, as you know, which involves party qualification and signature requirements on statewide independent nominating petitions. The case, all of the briefs have been filed, and oral argument has been scheduled for September 6th. In the DCCC case versus the state board of elections in relation to a number of aspects of relief that were sought by the DCCC, there was one component of relief ordered that we've discussed before with respect to the cure process being applicable when postmarks are not on absentee ballots between the 2nd and the 7th day post-primary. And at this point, all proceedings in that case have been stayed until after the general election. So more to come on that case, but right now it's in a holding pattern. In the Hernandez case, the state board is issuing weekly reports to the court, similar to the court's order, related to the status of implementing the remote access voting by mail process for voters with certain disabilities. That process, as Tom mentioned, is unfolding, and we are very much on schedule for that to be fully implemented for November. In the Brooklyn NAACP case, which we refer to as the line warming case, we filed a motion to dismiss June, and we are awaiting the determination of that motion practice. Similarly, in upstate jobs since the last meeting, similar to in the Green Party case, we filed what should be the penultimate appellate brief round there, and at this point, the oral argument has not been set, but would be expected probably in the September term. In the what I will refer to as the League of Voters 1 case related to the constitutional challenge under the state constitution, the 25-day voter registration cutoff. In that case, limited amount of additional discovery will continue, but hopefully that case will be mooted out if legislation is on the governor's desk with respect to moving the registration cutoff from 25 to 10 days. It's signed, so that case may go away. In the judicial watch lawsuit, federal case, we have until October 3rd to answer that case. That case basically deals with list maintenance processes in New York City, and conversations between all the parties are continuing to unfold in that case, which may be fruitful. The Schmidt case, which is the case related to the out-of-state witnesses having the ability to sign an affidavit that subjects themselves to New York jurisdiction, and thus allows them to be witnesses on independent nominating petitions. That case continues. We lost the PI in that case, but the case itself progresses. Most recently, we have the Cavalier case, which is essentially a challenge to 8400 of the election laws provision that times out at the end of this year that allows for absentee ballots for concern related to contracting communicable disease. The case is very similar to the Ross case last year. Our answer is due on 8/25, and at this point we fully expect the Attorney General to intervene in defense of the statute. Unlike the Ross case, we're the only state parties in that case, whereas in Ross there were any number of stakeholders that would have been defending the statute. Not so in Cavalier. Thus the likely Attorney General intervention. And let's see, in the Harkenrider case, there had been a motion to intervene on the part of the parent party, which was denied. At the Supreme Court level, an appeal was taken to the Fourth Department, and the decision of the Supreme Court of Savannah County was upheld. But just Friday, we did receive the motion on the part of the interveners for leave to appeal to the Court of Appeals. So that case has reawoken a little bit, and we will meet that motion appropriately. And let's see, the compliance staff work directly with staff in the enforcement division to get failure to file lists in sync. It is very clear that we have learned from past experiences, and I think that process for the July non-filing information that enforcement needs to do their work, that it went very well. There's excellent communication with the enforcement staff and the compliance staff back and forth to handle those issues. So that was very good, and the unit continues to process a great number of FOILs and also work on various subpoenas per usual. And the general work of the unit in reviewing reports that are filed with us continues. We are roughly speaking at 169,000 reports reviewed, and the rough math is there are about 12,000 reports in queue that still need review, which is also for this time of the year about on course. And finally, the staff informs me that for the July periodic, we referred 3,137 instances of non-filing on or about the 26th of July. And the staff reports to me that candidates and committees that have not filed as of 8/14 has dropped to 1,864, which from a historical context, that is good, and I think it reflects both the outreach of the compliance unit, but significantly the communications of the enforcement, which has been robust. And that's my report.
Any questions? No? Okay, thank you. We'll move on then to the enforcement unit, and that is Michael Johnson.
Michael, you're muted. Still muted. Looks like you're back to being muted. Now you're unmuted, but it's possible that your microphone is set to something that's not the right microphone, or are you dialed into the phone?
Or he could walk downstairs.
Or you could come down
That's
here.
another option. Goodbye. Maybe he's coming down.
Down there now.
Still there, but no.
We'll have it, while we wait for Michael, we can go on to the next unit. John Conklin and Jennifer Wilson on the NVRA PIO. Oh, I'm sorry.
Yep, we can hear you now, yes.
All right.
Nope.
No?
Still can't hear
Do
me?
the second. Yep, now we can.
There we go. Here's frozen now.
No, it's good.
That's definitely this bin.
Yeah.
Okay.
Let's go ahead.
Yeah,
We should ask him to come downstairs.
yeah, I think that's best.
Scroll down to the bottom.
Catch that microphone, use system settings.
You want to use the USB.
Michael?
We can hear you. I think we just need you to reactivate your video.
Well, actually, Michael, I think we would prefer if you just take the
Okay.
elevator
So
downstairs.
to go out and then go back in.
Can we mute?
Okay.
I can't mute him. He's muted down.
And,
All right, maybe somebody could tell Mike, we just, as soon as he came down, rather than going through this, if somebody could do that. And in the meantime, we'll move on to NVRA PIO. Jennifer?
Thank you, Commissioner. In July, PIO processed 126 FOIL requests. In August, 47. We've had medium to high phone volume the past 2 months. A lot of inquiries about the primary, a lot of inquiries about the party change rules and the changes to that. And you'll hear in this report, a lot of what we did was related to that, making sure folks knew about the new deadline. On the website, we made some updates regarding the new deadline. We also worked with DMV to ensure that their online portal reflected that the deadline actually was a day earlier through the DMV portal. We've made some cleanups to the home
Can you hear me
page.
now?
And
Michael, can you come downstairs? We moved on to NVRA and PIO, and the commissioners would prefer if you just come down.
I don't think he can hear us.
Is that what it
Can
is?
you hear me now?
TV?
We can hear you, but can you hear us?
I can hear you.
Okay.
Great. Michael, is there a chance you could come downstairs so we don't have to go through this?
Or what? Okay, I'm ready.
That'd be.
All right, I'm picking up from where Brian Quayle left off.
Oh, Michael, hold on just a second.
What?
Can you hear me? Hold on just a second. So we were in the middle of a report just now, Michael. Jennifer, why don't you finish and then we'll go back to Michael. Go ahead.
okay, all right, thank you. We also received a letter from 8 advocacy groups regarding the public reporting tool, recommending we make some changes, so we're currently looking into that, working with IT. On the MOVE Act, we submitted the 45-day UOCAVA compliance report to the Department of Justice. We're also continuing to field inquiries from overseas voters who are looking to vote in the August primary. On early voting, over the weekend, staff was on call to field any early voting inquiries. We're also currently tracking the early voting totals from the counties. On traditional media, following the court's order, we issued a press release regarding the new party enrollment deadline change, and we also respond to a lot of inquiries about that from the media. On social media in July, we held a training for county boards on some of Twitter's advanced tools, and we got some great feedback from that. We're also currently in conversations with Twitter to hold a more Twitter basics training for counties that don't have any Twitter presence at the moment. We'll schedule something after the primary for that. In July and August, we used our social media to further inform about the primary and also about the party enrollment change. And we posted 16 tweets to Twitter and 12 posts to Facebook in July and August, and we're continuing to inform about early voting. On the new ballot proposal, we added a section to the website for the 2022 Clean Water, Clean Air, Green Jobs, and Environmental Bond Act. We had the language translated as well into the 4 mandated languages. We're currently in conversations with press services to get our ad buys out there in time for the statute requirement to have that posted in all of the 62 county papers. On NVRA, the staff held a training for the New York State Department of Health WIC providers to review their procedures for NVRA processing agency-based registrations. There was 220 participants on that training. Staff did a great job. And the training was also recorded so that anyone who wasn't able to attend was able to watch it after. And then on grants, our new postage grant, OJS has finally approved our $4 million postage grant for the prepaid return envelopes that was implemented this past year into law. We're still waiting for those final contracts, but I have been told they are approved, so counties should be expecting them in the next few weeks, so that way they can get a piece of that $4 million to provide funding for their postage paid return envelopes. And then I have some grant totals here, but I think with Michael Johnson, we want to let him go. So if you have any questions, I'm happy to respond to them.
Any questions?
Right, yeah.
No, okay. Michael, we're back to you then.
Okay, great. We'll pick up from where Brian Quayle left off with regard to the non-filers. On July 25th, we sent a total of 3,842 emails to non-filers. And once we sent those emails out, as of the 11th of August, we got approximately about 257 or so bounce backs. And that was either the email address was bad, it was misspelled, or the recipient server rejected the email. In working with the compliance unit, the compliance folks were great in terms of us working together to get an accurate list out. We're still working on getting an accurate list. It's not 100% perfect yet, but we're really, really close to getting an accurate list all around. And what we did from that is from the 25th through the 31st of July, there were approximately 934 2022 July periodic reports that were filed. Of those, 330 were itemized reports and 604 were no activity reports. We then got another list from the compliance unit on the week of August 1st. This resulted in a list of 2,291 certified non-mailer letters that went out. They were sent on August 2nd. Now, between August 2nd and the 11th, there have been an additional 425 July periodic reports filed. Out of those, 146 were itemized and 279 were no activity reports. As of the 11th, there are still 1,615 committees that are still on the no filer list. Right now, it's a little too early to compare this list with the returns that we've been receiving back because we've been receiving certified letter returns on a daily basis. A lot of those returns are for bad addresses. Most of them tend to be for bad addresses or for people who have moved and the forwarding address instructions have expired. So that's where we are with the no filer project. As far as our LLC project is concerned, I'm in the process of reaching out to compliance to set up our next steps, because I know they're constantly updating the LLC lists in terms of the LLCs that are filing their statements of interest. So we need to sort of coordinate with them to find out, okay, how many are still outstanding, and then we'll take our next steps on that. To help with I know, Peter, you had a question with regard to, cases that were still outstanding. And as best as we could, we put together something for you guys with regard to the inactive cases, closed cases. And if you take a look at that, what you find is the division itself had a total of 357 cases that were open before the effective date of the regulation that called for the previous chief enforcement counsel to give notice to the board that cases were being closed. So, like I said, you had 357 of those cases that she closed with no notice to the board. After the regulation took effect, then you had all of the other cases that came on board. And you have that complete list in front of you of all the cases that were closed after the regulation, but the previous chief enforcement counsel deemed those cases inactive. So you've got that list in front of you of all of those cases that were deemed inactive.
Michael, maybe you could explain that term inactive.
Well, I will explain it as best I can from the folks who were here. My guess is inactive was a case that was deemed to have no further action was needed by the previous chief enforcement counsel. Now, it's important to remember it was her who reviewed all those cases that made the determination as to their inactive status. And my guess is the inactive category was used if cases were either referred to a hearing officer, referred to an outside entity, or if she deemed that no further action was going to be taking place on the matter.
So that's different from closed.
Yes, it is.
But it may also include closed.
It very well may. Again, this was recent determination as to whether or not a case was inactive. And since I really can't speak for her, nor have I talked with her, I can only tell you what I'm guessing as to why she used inactive.
But is it fair to say, from your standpoint, those cases there'll be no further work done on those cases?
That is correct, Peter. Now, since I came on board, there have been a total of 175 cases. Out of those 175 cases, 101 have been closed. And I've provided you with a list of all the closed cases to date. And a lot of those cases that were closed, there were cases that also, during my tenure, were administratively closed. And those cases which were administratively closed were closed because either no action was taken within 2 years, they were opened erroneously, and they were subsequently closed administratively. or they could even be duplicates. And that's why they would have also been administratively closed.
It's just a number, it doesn't really give us any information.
No, there's nothing here. So you've got three categories. You've got closed, you've got inactive, and then active?
No, you've got closed cases, you've got inactive cases, and then you've got administratively closed cases. The inactive cases, that was the creation of the prior Chief Enforcement Counsel. I have not used that designation.
So maybe you could help me with something. What's the difference between a closed case and an administratively closed case?
For me, a closed case takes place when an investigator or an attorney reviews the matter, does the investigation, finds out that there simply is not enough to sustain an allegation of an election law violation, or the matter has gotten resolved, and then the case is closed. As far as an administrative closed case is concerned, that could be a situation where you've got a duplicate matter that has since come in and we've already addressed it and it just got administratively closed. Or you could have, like I said, multiple complaints for the same issue. Or you could have a situation where someone looked at a matter and I took a second pair of eyes and made a determination, no, it should not be a case. Now, during the time when there was no Chief Enforcement Counsel, I had come across, there were quite a few matters that were opened that should not have been cases, and I administratively closed them.
So how many open cases are there now?
Right now, there are approximately, number, it's approximately 80 cases.
Have you made any progress on drafting proposed changes to the statute governing your operation?
Yes, actually, I have. We've talked. The staff has raised a couple of issues. We're still working through a couple of them, so I hope to have something for you guys probably by the next board meeting, in terms of just ideas or thoughts we've been thinking about with regard to different changes. For instance, and I know I might have brought it up to Peter, also Doug, I think I might have brought it up to you as well. One change that we had been looking at is adding the ability to send regular first-class letters with regard to the non-filers instead of just simply certified letters. Because I think that in this day and age, you have a lot of people who are more receptive to regular mail than certified letters. And also, we've had great success with regard to sending emails even. So off the top of my head, that's one in particular that I would like to see a change with regard to the statute.
I think another area that might be productive is to have a more expeditious procedure for fining non-filers.
Yes, that's sort of something that we have talked about, and the staff has looked at other states in terms of, because New York is one of, you have more states that actually have fee structures for fines with regard to non-filers. So we have been looking at that. We've been looking at what would be considered, a fair in terms of across the board, how we would break it down, non-filers, how far in advance do you need to give notice to folks? We've been looking at things like that. Also, we're looking at, as far as the fines are concerned, how the intake would work out. So we're looking at that as well. We're also looking at any possible changes to the hearing officer process to help streamline that a little bit better, because we have started bringing some hearing officer cases. So we'd like to try to streamline that a little bit more. And also, I'm taking a look at, I know we generate the quarterly reports, and I know, Peter, you've had some questions with regard to the numbers in the quarterly reports. And the issue with the quarterly reports is that it's not like a snapshot in time. The quarterly report will show you, for instance, how many cases are open and how many cases get closed. And the cases that get closed, it's sort of like not right then and there. That might be a case that we took in a couple of months ago. So sometimes those numbers don't always line up in terms of how many cases that came in versus how many cases get closed.
Okay. Anything else? Okay. Michael, I just noticed, just for administration, so on the cases closed document that you gave me, you marked it confidential. Is this confidential information? You marked all those pages confidential. I'm just curious, is that something that is confidential, the fact you closed a case?
No, that's not, that was just a computer glitch on my part.
Okay. Okay. All right, nothing else? Thank you.
Okay.
Then we'll move on to ITU. Michael Haber.
All right. Thank you, Commissioners. Good afternoon, Commissioners. So recently, IT has spent much of our time preparation and support of the elections this summer and related activity. As we're now in the August election cycle, as Exec mentioned earlier, we've begun our normal practice of daily touchpoint meetings with our various security partners, coordinated by our Chief Information Security Officer, Ben Spear. We've also, in support of that, coordinated to have comprehensive IT security coverage, both on election night and throughout the early voting timeframe. In terms of ongoing projects, we'll start with our online voter registration and automatic voter registration. Signed contract, as you may recall, has been signed here, approved by the Attorney General, has been sent to the Comptroller for final review and approval. We're looking forward to getting moving on that. We've also had dialogue and demonstration from the state currently using software on which our system will be based. And we have a draft MOU with that state. We continue also to have regular cadence of meetings with several participating automatic voter registration agencies, as well as state ITS and the county voter registration vendors. In other projects, the modified absentee ballot request portal, of course, has been up and running throughout this process, throughout this period, with added modifications and enhancements. The absentee ballot tracker was successfully deployed earlier this year, and we're currently in discussion with all of the voter registration systems to get them to be sending us all of the both required and the desired data elements to feed into that. In terms of space expansion, we discussed that at length a bit earlier. IT continues to work as part of that team, supporting the agency. Build-out is, as was mentioned, nearly complete the previously existing space on the first floor. And our development teams will be moving back there this week from their temporary swing space. We also are in the process of an infrastructure refresh or making preparations for it. We've begun those efforts to upgrade much of our server and storage infrastructure, which fortunately we're able to do with minimum amounts of downtime. Tapispitis, there were several updates that are in process for enhanced usability for the public reporting site. We've been working on that with CIO and compliance. There was recently added additional import capability for the electronic filing system to allow import of independently created files, such as Excel, with appropriate validation. And electronic filing system updates have also begun in support of the public campaign finance as an interim solution until that procurement is fully realized. We do continue to support public campaign finance in a variety of ways, much of which was mentioned in the previous meeting. In particular, I'll note again the successful development and deployment last month of the website there, which we are using as a model for how we may enhance our existing website for the entire state board by utilizing a similar content management system, perhaps hosting by the state ITS services. In terms of security, in addition to what was already mentioned, this month, the Secure Election Center staff spent much of July, the previous month, contacting county boards and county IT staff regarding the cyber regulation reporting, which was due on August 1st. These submissions that were received are under review, and we're working with local staff reaching out on any related questions to that. We continue to review options for continuing the intrusion detection and managed security services contracts, which we've had in place for several years for the county boards, as that's a very successful program we believe. We also continue to work with NISTEC and counties on implementation of their risk remediation plan efforts. And we are continuing to actively work with the SUNY Center for Technology and Government on the Future of Elections Infrastructure Project, along with representatives from all of the different units within the agency. And finally, I'll note that last week, Ben Spear and I attended the summer conference of the Multi-State Information Sharing and Analysis Center and the Elections Infrastructure Information Sharing and Analysis Center, hosted by the Center for Internet Security. There were positive interactions with many folks from both cybersecurity and elections professionals from across the country, and a good amount of information sharing. That's the end of the report.
Okay, thank you. Any questions? Must have been a great report. There are no questions.
Well, thank you.
Okay, so we'll move on. Our next is any old business? I don't think so. Any new business? I don't think so. Wait a minute. I'm
Very, very minor item.
Sure.
During the prior meeting, the TCFD approved a public hearing conducted by staff in relation to the approval of a resolution on the open meetings law provisions. I'm presuming that this board would want to act in tandem with that process for this board as well. So probably it would be appropriate for you to indicate the same sort of consensus in this meeting as was indicated in the last.
Any objections to that?
No.
Fine. Okay, with that said, I don't have any other new business unless somebody else does. If not, next meeting, I guess, is a topic. I was told September 12th. Is everybody on board with that? Everybody okay?
That's a Monday. Assuming your e-poll votes are done.
Make it done.
That's for it's to do the.
Well, it would also be to certify the general election ballot.
We don't do that.
They don't do that.
I don't think we have to do that. Okay, so the 12th is the next proposed meeting. And with that in mind, if there's no other business, I would entertain a motion to adjourn until that date. I'll second it, and, all in favor?
Aye.
Aye, and all opposed. So we are adjourned until September 12th. And thanks, everybody, for coming.